Today, it looks crystal clear that in our global world, the battlefield of peace and democracy is played more than ever by the rule of law and the respect to fundamental and human rights, opposite to the everyday, everywhere occurring crimes against humanity through all kinds of intolerance, fanaticism, and terrorism. Only 4 weeks ago, the most deadly phase of this scenario showed up in Paris. Terrorist jihadism, or jihadist terrorism, is now stronger, more powerful, better globally financed and organized than ever. It is hatred against respect. It is living together in peace versus the will to destroy democratic values, as easy and dramatic as that. Furthermore, transparency, efficiency in public action, and fight against any version of impunity must lead all our efforts as public servants and representatives. We are not here but to find solutions to the urgent demands of justice and equality of all the citizens we represent and serve. Let me please start with a brief general overview of the action of the European Union in promoting human rights and international law standards in its external relations, including the specific role of the European Parliament in this regard, in particular its subcommittee on human rights. Some of the main tools used by the EU to promote human rights in its external actions are the EU guidelines on human rights, as well as the common strategies, joint actions and common positions, the démarches and declarations, or the human rights dialogues and consultations with third parties. The EU guidelines on human rights are policy documents adopted by the Council. They cover issues of particular importance to EU member states: death penalty, torture and other cruel, inhuman or degrading treatment or punishment, children and armed conflict, human rights defenders, and international humanitarian law, to name a few. In addition to that, through the European Instrument for Democracy and Human Rights, which currently has an average annual budget of some 140 million euros, the EU funds a broad range of human rights projects across the world relating to the EU guidelines on human rights. But I would like to especially highlight and remark the essential importance of the human rights clauses in EU's external agreements. Since 1995, the European Community has sought to insert a human rights clause in all agreements concluded with non-industrialized countries. The human rights clause makes human rights a subject of common interest and part of the dialogue between the parties and serves as a basis for the implementation of positive measures on a par with the other key provisions in the agreement. In the event of serious and persistent breaches of human rights, the Human Rights Clause is an open window for members of the Parliament to demand third countries to respect human rights, enabling one party to the agreement to take restrictive measures against the offending party in proportion to the gravity of the breaches. I would like to introduce here a point of concern for your consideration. Countries who want to join the European Union have to meet the highest standards on democratic governance and human rights, as stipulated by the so-called Copenhagen criteria. But in recent years, the European Union was unable and unwilling to discipline members who do not respect the rules: deportation of Roma people, anti-gay laws, intimidating the media, undermining the independence of the judiciary, clandestine mass surveillance programs, complicity in torture programs, manipulation and abuse of electoral laws to eliminate opposition parties, impunity for corruption. In the absence of binding rules, the EU urgently needs effective instruments to ensure all its members abide by the rules. Like the Stability and Growth Pact for the Eurozone, the European Union needs a democratic governance pact, upholding the rule of law and fundamental rights. My political group at the European Parliament, the Alliance for Liberals and Democrats, is currently leading this initiative that I strongly support. The European Parliament contributes to the Union's policies and monitors the work of other EU institutions. Resolutions adopted by members help to raise awareness on human rights abuses. Resolutions may be a part of the legislative process, an outcome of own initiative reports drawn up by the parliamentary committees, or the result on the human rights debates that usually take place on the Thursday session of each Strasbourg plenary to highlight flagrant violations on human rights across the world. At the level of the committees of the European Parliament, issues relating to human rights in the world are specifically dealt by the Committee on Foreign Affairs Subcommittee on Human Rights, called DROIT. The subcommittee maintains close working relations with the European External Action Service, other EU institutions, and human rights NGOs, as well as multilateral human rights institutions. The European Parliament, as the only directly elected EU institution, is strongly committed to developing EU policies in support of democracy throughout the world. The European Parliament's committees, as well as the standing interparliamentary delegations, conduct official delegation visits to third countries. The joint parliamentary assemblies bring together members of the European Parliament and parliamentarians from third countries to discuss common challenges, including human rights and democracy issues. These assemblies are currently the ACP-EU Joint Parliamentary Assembly, the Parliamentary Assembly of the Union for the Mediterranean, the Euro-Latin American Parliamentary Assembly, and the Euronest Parliamentary Assembly. And last but not least, the European Parliament's Sakharov Prize for Freedom of Thought honors exceptional individuals who combat intolerance, fanaticism, and oppression to defend human rights and freedom of expression. The 2014 Sakharov Prize was awarded, as you may know, to Dr. Denis Mukwege from the Democratic Republic of Congo. By awarding this prize, the European Parliament acknowledged his over 30 years of admirable work struggling for women's dignity, for justice and peace in his country, giving medical, psychological, and legal care to thousands of women and girls, victims of sexual violence, often forced to keep silent to avoid being ostracized. Dr. Mukwege unceasingly stresses the need to fight impunity and prosecute the crime of mass rape, as it is used as a weapon of war and terror against innocent and fragile human beings. This is a strong signal to the government of the Democratic Republic of Congo. The Congolese are thirsty for peace and justice. They can count on the unrelenting support of the EU and the international community. The European Parliament is seen as the most principled and outspoken EU institution within the field of human rights. To strengthen its effectiveness, the European Parliament should make some adaptations, strengthen contacts with civil society in third countries to reinforce the institution's position as a supporter of human rights, increase its internal coherence and coordination across different instruments, exploit the powers granted by the Lisbon Treaty to promote an effective and common EU human rights strategy, and to have an effective and binding instrument supplementary to Article 7 of the TEU, available to respond to situations of member states not complying with Article 2 of the treaties. From my point of view, the best way to serve human rights interests from the international law perspective is to strictly maintain independence and efficiency, avoiding any kind of misuse or misleading of its mission and actions. International community, in particular governments, legislators at the national or supranational level, members of the judiciary, the legal profession and legal scholars, representatives from global governance institutions and NGOs, etc., must make every effort to preserve the impartiality and independence of the ICC and other international criminal tribunals, and keep them away from any form of politicization. They come to existence to administer justice and not to advance anyone's political agenda. International criminal tribunals are a relatively recent development on international law, beginning with the Nuremberg trials created 70 years ago after the Second World War. They typically entail legal consequences at the level of individual criminal liability rather than state liability. They mean a great contribution to strengthen the rule of law and avoid impunity. The ICC is today the most notable example of an international criminal tribunal. The Nuremberg Charter stipulated the crimes to be prosecuted. 3 categories of crimes were defined: crimes against peace, war crimes, and crimes against humanity. The rulings and legal principles laid down by these tribunals were later codified into the Nuremberg Principles, which in turn were the basis for other international criminal tribunals constituted since then, as the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, or the Special Tribunal for Lebanon. I would like to point out some specific attributes of the Special Tribunal for Lebanon. The STL's 11 judges, a combination of Lebanese and international judges, are appointed by the UN Secretary General for a renewable term of 3 years. It is unique among international criminal tribunals in that it may hold trials in absentia. Further, it is the first international criminal tribunal to deal with terrorism as a distinct crime. In 2011, the STL established the elements of the crime of terrorism and laid down the groundwork for its definition and codification in the future. On the basis of treaties, UN resolutions, and the legislative and judicial practice of states, there is convincing evidence that a customary rule of international law has evolved on terrorism in time of peace, requiring the following elements. 1. The intent, dolus, of the underlying crime, and 2, the special intent, dolus specialis, to spread fear or coerce authority. 3, the commission of a criminal act, and 4, that the terrorist act be respect of crimes committed before the date on which the declaration was, the 4 point is that the terrorist act be transnational. The very few states still insisting on an exception to this definition of terrorism can at most be considered persistent objectors. The STL was chaired at that time by the reputed Italian jurist Antonio Cassese, whose impartiality and knowledge in the matter are indisputable. Beyond these mentioned ad hoc tribunals that I said before, the International Criminal Court is a permanent tribunal. The ICC has jurisdiction to prosecute individuals for the crimes of genocide, crimes against humanity, and war crimes. As of 2016, it will include the crime of aggression. It is intended to complement existing national judicial systems, and it may therefore only exercise its jurisdiction when certain conditions are met, such as when national criminal courts are unwilling or unable to prosecute criminals, complementarity, or when the UNSC, the United Nations Security Council, or individual states refer investigations to the court. The ICC's prosecutor may initiate investigation on their own on the basis of information of crimes within the jurisdiction of the court. The ICC began functioning on July 1st, 2002, the date on which the Rome Statute entered into force. As we all know well, the Rome Statute is a multilateral treaty which serves as the ICC's foundational and governing document. States, which become party to the Rome Statute by ratifying it, become member states of the ICC. The ICC has territorial jurisdiction and personal jurisdiction. A state which is not party of the Rome Statute can accept the jurisdiction of the ICC by lodging an ad hoc declaration with the registrar. The requesting state may authorize the court to assume jurisdiction in respect of crimes committed before the date on which the declaration was filed with the registrar. The prosecutor will initiate an investigation when is satisfied that, first, the alleged crime committed or being committed is under the jurisdiction of the court. Second, the situation is not being investigated by the judicial system of a state, an ICC member state or otherwise, with jurisdiction over the alleged crime complementarity, and that the crime is of sufficient gravity. Issues regarding complementarity and gravity make up the admissibility analysis. And third, the investigation will serve to interest of justice. The ICC system has been subject to a wide array of critics, such as many criticize the Rome Statute for conferring excessive powers upon the UNSC, whether to refer a situation to the court or, on the contrary, to halt an ongoing investigation by the court. Other critics have come from African leaders, raised objections to the ICC for their disproportionate focus on poor African countries while being remiss in addressing its attention to more powerful countries. Another raised criticism to the Rome Statute for not defining the crime of terrorism as a distinct crime. The reason given for that omission was that there was no consensus among the international community about the elements and criteria to define that crime. Professor Kassese, president of the Special Tribunal for Lebanon, as mentioned before, asserted that these arguments were no longer valid and was critic to those very few states that insist on the impossibility of defining the crime of terrorism. Israel signed the Rome Statute but withdrew from it in 2002, inter alia, on grounds of the omission to include the crime of terrorism in the Rome Statute. Being those previous considerations said, I think this is a good opportunity to make a reflection on the most recent and controversial case raised to the ICC agenda. Last month, Palestine lodged a declaration accepting ICC jurisdiction over alleged crimes committed in the occupied Palestinian territory, including East Jerusalem. But 3 months before, the prosecutor Fatou Bensouda stated, 3 months before, that Palestine status was upgraded by the General Assembly of the United Nations to non-member observer state, and the office examined the legal implication of this development of its purposes and concluded that while this change will not retroactively validate the previously invalid 2009 declaration lodged without the necessary standing, Palestine could now join the Rome Statute. My last reflection: by anticipating Palestinian fulfillment of statehood criteria, which could lead to a valid filing of a declaration accepting ICC's jurisdiction and Palestine becoming a new ICC member state, ICC prosecutor Mrs. Bensouda could prejudice Israel. I'm far from being a specialist in law, but evidence shows that Mrs. Bensouda decided the matter of Palestine statehood without being legally entitled to do so. The prosecutor's behavior seems to have been out of place, and I would like to state again that my main concern is the possible misuse of key international justice resources meant to be devoted to its well-defined judiciary mission, as well as the undermining of the ICC's impartiality and credibility. Finally, referring just to the European Parliament resolution of November 2011 on EU support for the ICC, whereas pursuing the interest of justice regardless of political consideration is the founding principle of the Court, whereas the ICC plays a key role in promoting international justice and contributing to security, justice, and the rule of law, as well as to the preservation of peace and the strengthening of international security, let me just end this questioning, and I hope not too disconcerting speech, suggesting a concrete initiative for the progressive development of international law in the matter of international criminal tribunals, definitively defining the crime of terrorism and including it in the Rome Statute so that it could come into the ICC's jurisdiction for its effective prosecution worldwide, as the STL set the groundwork. Impunity cannot and must not be an option. Thank you very much.